Okay, so it's 4:30, so I'm going to formally start the webinar. As many of you will know, I'm not actually Deborah Gold. I'm Polly Lowe. Deborah is unavailable today, and I've stepped in and I'm piggybacking off her Zoom account. I'm a member of the family team at Fenners Chambers. Welcome to everybody who's managed to join us live. So we're up to 80. And welcome to those people who will be watching the video at some later date. This webinar is brought to you on behalf of the Local Family Justice Board and Fenners Chambers to discuss adoption reform. We will be hearing from Lisa Hannant, who's also a member of the family team at Fenners Chambers, on the recent case law on post-adoption contact and the public law working group proposals. We're then going to hear from Jade, Cullum and Tom Hay from Cambridgeshire and Peterborough Adoption Service about the impact of those proposed changes on adoption and family finding practice. And then finally, we're going to hear from Her Honour Judge Gordon-Saker, who is our designated family judge for Cambridgeshire and Peterborough, on the court's expectations of contact proposals where there's an application for a placement order. There is a facility to ask questions you can type your questions into the chat, and then if there's time at the end, we can put those questions to the panelists. So I will hand over to Lisa.
Hi everybody, my name's Lisa. I will just share my screen, bear with me. Which I hope is now showing. I'm looking for a thumbs up from Polly there, that it's all visible. I've been asked to talk to you about the law as it stands, the developments in the case law, and also the public law working group from last year that was published in November. It was quite a busy time towards the end of last year with these recommendations and people reading them and working out how they were to be pulled into our work at court. I understand that the slides and or recording are made available through Fenners, and some of my slides, just as a warning, have quite a lot of detail on them, which I won't be able to go through fully in the time allowed, but that you may find useful to look at a later time. The starting point, as always, is the statute. That is the Adoption and Children Act 2002. There's been no changes to that existing statute. The issues about how, in our cases, we apply that statute in light of the research that we now have. The starting point at the placement order stage is at Section 26 and Section 27. The court may make an order requiring the person with whom a child lives or is to live to allow to visit or otherwise have contact with a person named in the order. That can be an application made by a wide variety of people, and they are named in Section 26(3), including parents, guardians, relatives, anybody named in the live with order, and so on. Or it can be of the court's own motion. And it lasts, any order under that section, through the operative period of any placement order. So it would end if the placement order is revoked, and it would end if an adoption order is made. So it is, I would observe, something that can last quite a long time if a search takes quite a long time for a placement, or actually you can in some cases be only looking at a very short period of time. The important point when you are at court is sections 27(4), and you'll note the wording that it is a must, that is the court's duty before making a placement order to consider the arrangements essentially for contact and to invite parties to proceedings to comment on those. And the court can also make conditions attached to any contact order. So it has a very wide discretion in the statute as it exists. On my next slide, we deal with the adoption order stage, so the later stage, and that combines section 46 of the Act with section 51 capital A. You'll note again that it's expressed as a must, that the court must consider arrangements for contact at that stage before making an adoption order. And 51A, when making the adoption order or any time thereafter, the court can make an order requiring a person named to be able to spend time with the child, or indeed prohibiting a person spending time with that child. So there is the two limbs to it. A few things to note on this slide. The list of persons named in an order, again, is very wide under section 51A3. It includes relations and goes as far as to say of the blood or half-blood, guardians, somebody who had parental responsibility, anyone who was entitled to apply under section 26, anyone with whom the child has lived for a year, and so on. Persons who may apply is defined in section 51A, subsection 4. Shorter list, the person who has applied for the adoption order, the child, or anyone who has leave, and the leave test is in section 51A5. That you will recall, it looks at any disruption to the child to such an extent as being harmed by it, so by the application itself, so a relatively high test, the connection to the child and any representations made by the child or the applicant for the adoption order. It is important to note the timing of section 51A, that essentially that application for leave could come a long time after an adoption order, because it says at any time thereafter. The ability of the court to make orders of its own motion is slightly less. It can only make the order to prohibit contact under 51A 2B, and again can have directions about how to put that contact into effect. So it is a very wide discretion under the Adoption and Children Act, and provides for the court to consider contact at the time of making the placement order, at the time of making the adoption order, and at any time after the adoption order is made. So a number of stages within the law that we have. The starting point in terms of the case law, I've simply put on this slide some quotes from Reed B 2019, a judgment from the Court of Appeal by the President, Sir Andrew McFarlane. It's a good case to revisit because within it, it looks at the law before that time. And this remains the starting point as I understand it. Within that judgment at paragraph 59, the President looked at the Adoption and Children Act and commented about debate and research amongst social work and adoption professionals, which may be moving towards the concept of greater openness in terms of post-adoption contact, both between an adopted child and natural parents, but also including siblings. He said that the impact of the new research is likely to be reflected in the evidence adduced before the court. But as set out in my quote there, any development or change from previous practice and expectations as the post-adoption contact that may arise from these current initiatives is a matter that may be reflected in welfare decisions that are made by adopters or by the court on a case-by-case basis. These are matters of welfare and not law. And the law remains, namely that it will only be an extremely unusual case that a court will make an order stipulating contact arrangements to which the adopters do not agree. I've also put a quotation from paragraph 62 on the slide from the same judgment, where it says orders at the placement order stage, 26 and 27, the court's order can set the tone for future contact. That is a recurring theme or language that you will hear through the case law that I come through about the duty on the court to set the tone or to set the template for ongoing contact in appropriate cases. The next slide, the developing narrative over the last year and a half or so sets out some of the important reading. I can't in any sense begin to do these pieces of reading justice in the time that I have, but I flag them. They are a good read in my view, and they do look at how things have progressed. You have the interim report in September 2023 from the Public Law Working Group. Of course, now we have the final report, but this was the report the year before, speaking of a main recommendation of a tailor-made approach to the issue of contact for each adopted child that includes and promotes face-to-face contact with important individuals if it can be safely achieved. We then had the November 2023 lecture by the President, Adapting Adoption to the Modern World. He endorsed the Public Law Working Group interim report, and he made some additional observations. I have noted that when speaking about the placement for adoption phase, he said in many cases the consideration of contact may be confined to the immediate cessation of the current arrangements, with little or no thought being given to the medium and long-term support that can be given to the child prior to, during and after adoption. My own view, he said in the lecture, is that there is a need for a radical departure from that model. It should be the responsibility of the court at this key stage when it has determined that a child is to be adopted, but before the adoptive placement has been identified, to establish the basis and structure for continuing relationships with the birth family. He went on to say that the concept of modern adoption needs to be developed further so that services are improved, with, in particular with regard to provision of a continuing relationship with the birth family, with the child's needs being at the centre of all that we do. He said that every adopted child has the right to know less. Speaking again in May 2024, Adapting Adoption to the Modern World Part 2, the Potato Conference, as per my quotation there at page 13, he said that the family judiciary have an important part to play. Orders for contact made under Section 26 set the template for contact going forwards. Where continuing contact in some form is ordered, that will be an important known about the child to be taken on board by any potential adopters. He also mused in that lecture about the use of Section 51A and whether it could provide a review of contact sometime after an adoption order. And he also said, which in my view is perhaps most important, that the question of contact should never be seen as an add-on issue, either at the placement order stage or at final adoption. Rather, it should be centre stage and seen as an integral part of the child's support package as they move on towards adoption, adolescence and adulthood. So those lectures and the transcripts are available online, are worth a read. Certainly if anybody is looking for any good material for skeleton arguments or so on. Looking then ahead to 2024, a couple of reported cases that I've put on that slide, the Luton case and the Reed DS case. The Luton case was Richard Harrison Casey sitting as a Deputy High Court Judge, and the Reed DS case was the Court of Appeal on appeal from his Honour Judge Tolson, the lead judgment from Peter Jackson, Lord Justice Peter Jackson, I should say. Each case, of course, always turns on its own facts, We say that in the family court all the time, and it's true that the particular circumstances of particular children lead to, of course, particular outcomes. In Luton Borough Council and C, the child C was 5 and had been in the same foster care placement for 4 years. So it was essentially the only home the child really knew. The child had significant additional medical needs, so needed more than adequate care. It has a complicated history, but to summarise, the foster carers wished to adopt, and the court considered care orders, special guardianship orders, and adoption, and found that the overriding need for stability and security meant that an adoption order should be made. But in terms of contact, no contact order was made. At paragraph 157, the court said, "So far as contact is concerned, I do not consider it appropriate for me to make an order for post-adoption contact. Despite the recent research about the potential benefits of ongoing contact, it remains the case that it will rarely be appropriate to impose an order upon unwilling adopters." So there was a recital only that Mr. and Mrs. D, the adopters, were agreeable to a further period of wishy-well contact, to facilitate indirect letterbox contact twice a year, and to keep the question of direct contact under review. The next case of re-DS is, in my view, an interesting case. It looks at essentially the conflicting welfare needs of the need for a stable family home and needs to stay in contact with relatives, particularly siblings. The facts, very briefly, with one eye on the time, the child C was 11 months old, nearly 1 at the time of the trial, and she had siblings who were 10 and 5. The plan for the older 2 was for long-term foster care. The plan for C was adoption, and the care plan included direct contact twice per year with the siblings and with the parents. The trial court, His Honour Judge Cholson Casey, refused the placement order, made care orders, was of the view that contact should be fortnightly with the siblings, and felt that there was a gap in the analysis of the professionals when comparing long-term foster care versus adoption. The Court of Appeal made the placement order, didn't direct a rehearing, and did not make a Section 26 order. They said at paragraph 17, "We will make a placement order on the basis of the local authority's plan, which aims for there to be some contact before and after adoption. We will not make a contact order because that might complicate the search for adopters, which must be the priority." There was quite a lot of discussion in this case about what the predominant welfare factor was for C, who was very nearly 1 year of age. And the Court of Appeal said from its reading of the judgment below that the court appeared to consider the predominant welfare factor to be the benefit to C of her parents and half-siblings being a regular presence in her life. Paragraph 52, the Court of Appeal said that their welfare evaluation can be quite shortly stated that the dominant feature of C's situation, in my view, is her particular needs at her very young age. At the heart of this matter, she needs a lifelong family where she can feel she belongs, and spending a whole childhood in foster care is absolutely not the same, even if good and permanent carers could be found. And the reason why long-term foster care was not looked at more closely by the professionals was because the Court of Appeal said it was obviously a very poor plan for C's future. So whilst noting the importance of those sibling bonds, they did not, the Court of Appeal said, outweigh the predominant need for her to have a family of her own, and concluded at paragraph 55, which I've placed on the slide, from a welfare point of view, I therefore find that the advantages of adoption for C are overwhelming, and further consider that the interference with the convention rights of the parents and the siblings is necessary and proportionate because adoption is the only way of meeting her needs. Any interference may be mitigated if contact can be arranged, but even if it cannot, the outcome is the same. So it is, in my view, an important case looking at the Court of Appeal did at grappling with a need for family life and stability with the contact plans, but no contact order was made. Essentially, the plan was approved, the care plan looked to have some direct contact of a low level, and it was essentially left with the local authority going forwards. On to my next slide, the big case, I suppose, towards the end of last year on this topic is re R&C, the Court of Appeal. The judgment, Mr. Justice Baker, was the 30th of October 2024 on appeal from His Honour Judge Wicks, 1 week before the Public Law Working Group's final report was published. It is, in my view, essential reading for those of us dealing with these cases at court. It is a 28-page judgment, and so I will do my best to summarise it for you as the time allows. It's a good judgment in the sense that it reviews all the case law, so is it of assistance, a good place to start. But there were 4 children, aged 6, 5, 3 and 2. And there had been previous proceedings and a placement back in the mother's care, but sadly it had fallen apart. And so this was the second set of proceedings. The local authority's case was long-term foster care for the older 2 to be placed together, and adoption for the youngest 2 together, which the guardian agreed with. The parents opposed. The care plan provided for sibling contact for all 4 children for a minimum of 6 times per year. The older 2 were to continue seeing mum because they were to be in foster care. Direct contact for the younger 2 and mum was to cease. An important context of this case, because it is fact specific, is the quotation at that first bullet point, which is what the local authority's final statement said. And it said that they will not defer from finding families who are aware of and are fully prepared to support the children in maintaining their sibling links. Without this, the local authority are of the firm standpoint that they would not be the right families for the children. So a bold statement in the final evidence, you might think, but it certainly set the stall for the adopters that they were looking for. The court, however, refused to make the placement order, made a care order and directed new care plans to be filed for long-term foster care for all 4 children, and the local authority appealed. The judgment sets out His Honour Judge Wicks' evaluation of adoption and long-term foster care, setting out the positives and negatives of each as is required by the law. And he said that permanence comes at a significant cost, namely the complete and irrevocable severance of all ties with the natural family. This can sometimes be ameliorated by continued contact between the birth family and the child, but that, he said, it is at the discretion of the adopters. In this case, the local authority committed to search only for adopters willing to promote direct sibling contact, and that commitment is a tacit recognition of the importance of the sibling relationship. But sibling contact cannot be guaranteed. Even adopters who are open to it may not continue to promote it after the making of an adoption order. And given, he said, sibling relationships had a critical importance, its maintenance couldn't be guaranteed in adoption, and he refused to make the placement order. Not so, said the Court of Appeal. The local authority's submissions on appeal set out, and they are at paragraph 57 of the judgment. To summarise, they set out the critical difference between, they said, on the one hand, imposing an order on adoption on adopters. Sorry, let me start that again. The critical difference, they said, on the one hand, from imposing on adopters a contact regime that they had never bargained for in respect of a child previously placed with them, and on the other hand, crafting a contact regime at the placement order stage so the eventual adopter accepts the adoptive placement with their eyes wide open to the court-directed imperative for long-term sibling contact. Within the latter regime, the court will set the tone. It was, in that sense, a known, as the President said in his potato lecture. The Court of Appeal said that to say that permanence comes at a significant cost may have been true of all adoptions at one stage, remains true of some adoptions now, but is emphatically not true of many adoptions, and it is at odds with the concept of open adoption, which is paragraph 66. They said that the judge overlooked that it was his duty to set the template for contact going forwards, and concluded at paragraph 68, as per the slide, that it is unusual, extremely, to make an order stipulating contact that the adopters do not agree with, but that does not obviate the court's responsibility to set the template for contact at placement order stage. In this case, the local authority was committed to search only for adopters willing to accommodate sibling contact and invited the court to make an order under section 26. There was a possibility, the Court of Appeal said, that the search for adopters might be unsuccessful, or adopters might subsequently refuse to agree contact. But in the circumstances of this case, that possibility was not a sufficient reason to refuse to make the placement order. I've set out the order from that case on my next slide because it is about, in my view, crafting the recitals, and they were along these lines in the reported case of R&C, to set out what the contact care plan is, to set out, if that is the case, that those are the adopters you're looking for, a commitment to return to court if there is a significant change to the care plan within a period of time, and to set out the court's view if it endorsed that care plan, namely the importance for contact 6 times per year. So it is, in my view, an important case to set the template, to look at what is a known about these children, and to craft your recitals to reflect the care plan. I've used this sort of thing since this case, in a case I can think of where there was one child subject to a special guardianship order, the next child was subject to an adoption order, and then the child in proceedings was in foster care with the local authority seeking a placement order, and the plan was for 6 times a year sibling contact. The court, in my case, didn't make a section 26 order, probably because of the no order principle. I don't think it would have necessarily been wrong, but that contact between those 3 siblings was happening on the ground on a bi-monthly basis, and it was the plan that would continue whilst the search for adopters carried on. So it's adaptable in terms of its guidance, but it is, in my view, important. That leads me to the Public Law Working Group of the 7th of November 2024. It goes without saying that it is important reading for everybody practicing in this area. It is 170 something pages, I think, and I will focus on chapter 1, which is about adoption and contact. And again, in these slides, I can't mention everything on them, and I can't do every recommendation the justice that it needs, but I'll try to summarise perhaps the key points. You would have read that the authors drew on research from Australia, from Wales, and also from Northern Ireland. They said that there was considerable evidence that transparency and openness around circumstances of birth family is beneficial to adopted children, that the purpose of post-adoption contact is to enable the adopted child to understand their experiences and develop a sense of identity, that separating siblings can lead to a sense of enduring loss, and that there are strong indications that face-to-face contact helps to develop identity, accept the reasons why they've been adopted, and move forwards. But ensuring contact is safe, they said, was pivotal to positive outcomes. And despite research about the benefits of direct contact, if safe, the overwhelming majority of cases continue to recommend letterbox contact only, but that could be problematic and not always maintained. And that the experience in Northern Ireland suggested that a shift in the mindset of professionals and strong guidance from the judiciary can bring about change without changing primary legislation. So their main recommendation at paragraph 42 is on the slide, a tailor-made approach to the issue of contact that promotes face-to-face contact with important individuals if it can be safely achieved. Note important individuals, it can be wider, of course, than parents, to include siblings and wider family. There are some general recommendations about consistent training for prospective adopters, at its core looking at the lifelong needs of adopted people, ongoing training for social work practitioners, lawyers and the judiciary as to the benefits of open adoption, and birth parents signposted to independent support to allow them to understand how they can remain involved in the child's life, which I think the adoption regulations do require signposting to support in any event. Paragraph 71 then sets out the need for a sea change in the approach of the question of face-to-face contact. It's recognised that it's not safe for all adopted children, but the current system whereby face-to-face contact is the exception rather than the rule is outdated. So it is a bold statement looking to change really the approach going forwards. There's then all sorts of recommendations about pre-proceedings and within proceedings. I pause to say that some of this, no doubt, will be to an extent dependent on resources that are available. I don't know how those resources will develop over time. And clearly the extent of inquiries made will also vary depending on the circumstances of particular children. But pre-proceedings, essentially the message is to expand your inquiries through the FGC and eco-mapping for important relationships, who's significant, who can reassure the child they're remembered, who can facilitate positive contact. And it goes beyond the siblings, including aunts, uncles, nieces, godparents, and so on. And it's looking at doing that at the pre-proceedings early stage. So even if those people are not able to care full time as alternative carers due to illness or age or youth or working requirements, they may have a positive contribution to make. Within proceedings, which is much more where my take on this begins, is that the full range of contact options have to be considered by the social worker, guardian and the court, rather than an assumption of letterbox contact only, which is page 41. So looking at who could be a positive influence, assessing whether they can maintain it if there's initial optimism that somebody may be appropriate. And it says, paragraph 82, an additional paragraph in the final social worker statements about contact. So what contact has been considered post-adoption, the welfare benefits of it measured against any safeguarding issues, so that a fully reasoned recommendation can be made, and the reason why each type of contact is ruled out or ruled in, or whether it may be looked at again in the future. If it's an actual recommendation for direct contact, it needs some flesh on the bones. What's the duration, frequency, venue, who should source it, and so on. So that is what we will need to see in final evidence before the court. I would defer to Her Honour if she disagrees, but my own view is that a narrative in the statement of a paragraph or two should be sufficient to set out the rationale for contact, the reasons why certain forms of contact have been discounted or not, and the welfare recommendation. I don't think it has to be, certainly in most cases anyway, an all singing, all dancing kind of fancy table setting out each possible type of contact that could ever be conceived, the pros and cons of it, and then a recommendation at the end. I think it needs to look with realism about what the contact options are and be able to give a welfare evaluation as to the recommendation for this particular child. Other recommendations within proceedings: if it's letterbox, is it digital, or if not, why not? For the final care plan, to have an additional section about post-adoption contact, specific consideration of sibling contact, which might require work with their carers too, and a contact support plan in draft at the final hearing stage. Again, I'll defer to Honor whether that should be a separate document or included within the final care plan itself, but it just needs to be addressed, say, the public law working group. And for the guardian to step back and ask whether the post-adoption contact assessment is broad enough, has it been explored sufficiently? For the court, that's addressed at page 44 of the report. The court needs to look at section 26, as I've set out in the slide. Does the court wish to make any orders to set the tone for what is planned will happen after any adoption order to ensure that gaps do not occur, and for the court to consider section 51A, which contemplates contact orders at the adoption stage, or to facilitate a review at a future time. It says if that's indicated in the foreseeable future. I don't know what the foreseeable future means, particularly, and I suppose that would vary case by case as well. There are then a list on this slide of other recommendations. Some of these are already good practice, I would suggest, such as the later life letters and life story books, and indeed documents being shared which are balanced in their approach to be given to prospective adopters. Paragraph 92, I've coloured in bold, really just to touch on that direct contact should be expected to continue, it says, in early permanence places where it has been working well, and any obstacles need to be explored and addressed. It didn't really have centre stage in the report, that paragraph. It was rather buried later down in the recommendations, and in my view, it's relatively important. I don't know how many early permanence placements we have, but I see them fairly often. And the last one I can think of, which came to final hearing, there was a recommendation for twice a year contact to continue at a centre with the parents and the child. And the plan was compliant with these recommendations as to who would organise that, who would fund it, what support the parents would need. And that was a case where the final evidence was filed before the public law working group. And so it was pleasing to see that that was in line with what they had to say about early permanence placements. So in summary, bringing matters up to date, the law is already there. The public law working group guidance is about how to use those statutory powers, and is also aimed at improving the quality of the evidence before the court when the court has wide and flexible powers. I don't know what resources will be able to be put in place in the near future for those additional services that would be needed to fully meet the recommendations of the public law working group. But I do think that we can now, in final evidence from all professionals, have that analysis to assist the court of what specific contact is recommended for this specific child or children, and what orders are sought, if any, so that there is a wider analysis of the plans and not a default analysis, as has been mentioned by the public law working group. It doesn't mean, of course, now with a sea change that every case will now have direct contact, but it does mean there'll be a more specific analysis of post-adoption contact and bespoke plans for each child to justify the rationale. The optimism of the public law group is at page 45, where they note that it would be, as B said, unusual to make an order against the wishes of adoptive parents. But they say that adoptive parents need to be fully involved in decisions about contact, with a strong emphasis on the needs of the child. And if other recommendations in the report are accepted, we hope that with greater support and training for all concerned, that decisions about contact are overwhelmingly likely to be made by consent. So that's the optimism there. We will see, I suppose, over the next year or two, if that is the case. I would also say that the appendix to the Public Law Working Group has a nice list of cases. If anybody's doing any research in this area, it's in a nice tabular form. And lastly, after the Public Law Working Group, I have been looking on Family Law Week and Westlaw. My disclaimer is that this is up to date as of Tuesday afternoon, and these were the ones that I had found up until that date. 5 so far that I have found reported, nothing particularly life-changing. It was only in the Nottingham case, the second one down, where there was a Section 26 order. In that case, there were 3 children who were siblings. The local authority was seeking adoptive placements for all 3, but to be together in that placement, which they acknowledged might be a challenging search. And so if they couldn't place them together, the backup care plan was separate adoptive placements with direct contact between the siblings. And so the court made a Section 26 order for sibling contact, wasn't invited to, particularly by the guardian or the local authority. No frequency was set, he said, for reasonable contact during that period, to set the template for contact going forward, because he said he had the welfare evidence now that these children would need more than letterbox contact between them if they were placed separately. Otherwise, the other cases really do turn on their own facts, and I am conscious of the time. So I will hand back to Polly now, because that concludes my slides.
Oh, thank you, Lisa, for drawing those threads together for us so well. And we're now going to hear from Jade and Tom about the implications of this direction of travel on adoption and family finding.
Evening, everybody. I'm just going to share my screen. Polly, please give me an indication if it's not worked. Can you see everything? Yeah, brilliant, thank you. So evening, everyone. I'm Jade Cullum. I'm the agency advisor for Cambridgeshire and Peterborough Regional Adoption Agency, and I have my colleague Tom Hay, who's the family finding team manager here also. I'm going to start the presentation, then I'll stop sharing and let Tom continue. So Cambridgeshire and Peterborough Regional Adoption Agency works across both Cambridgeshire and Peterborough City Council, and we provide a range of services. I just thought it'd be important to note really that we are separate to the children's team, so we are not the teams making the plans for children, but are obviously linked into them. We have 4 main areas, which are myself in panel, and a QA role across adoption paperwork. I won't go into every detail. You've got the details on the screen and you'll get the presentation. We then have family finding, which is Tom. We have the recruitment and assessment, and we have Kelly Johnson, who is the adoption support service team manager. So they're the 4 main areas across the service. So we are responding to the public law outline, but also responding to research. So in particular, the University of East Anglia has significant research, and the last of these I've put on is the evaluation of the letter swap, the digital platform, which might be interesting to those of you who are new to the digital platforms. It's an area that we're exploring as a regional adoption agency currently. So the message from the outset, this is the message we give to adopters. From the very beginning, there is an expectation that they will support an adopted child to maintain significant relationships. So modern adoption is supporting adoptive families to stay in touch with birth relatives where it's safe to do so and where it's in the best interest of children. So we're reframing how we provide all our material to adopters from the front door all the way through their journey to be matched with children. We've changed the language so that there is an expectation that they will have an opportunity to meet birth parents. So this could be more than once. The terms used to be a one-off meeting prior to children being placed, but that's changing. And we want to make sure that we're being creative and that birth parents can be engaged with at different points when they're ready. Across the agency, we follow the University of East Anglia's model for transitions, and that's around encouraging ongoing relationships with foster carers, which again, I think helpfully reflects that people who previously cared and been significant to children don't disappear, that those relationships can be maintained and can be supported. And that's been very successful in helping children to settle. The other message we give adopters is that plans for keeping in touch with children and their birth families is going to change. So what may have worked at the point a child is placed at 1 or 2 will not be sufficient as that child gets older and has additional questions, but also that adoptive families' positions change, and so do birth families, that they are often in very different positions later down the line. And we need to take into account that their situations might have altered. They might successfully have children with them, and plans can be revisited. The start for us really across the adoption team is that it's around helping everybody making decisions about children and adopters to understand that the benefits to keeping in touch really are there for the children. That's why it's important, that it helps people to integrate the past. It helps to have a coherent narrative of children's stories. It makes sense of being part of 2 families. Significantly avoids the stress of searching for birth families later on, which we know is the reality really, particularly in the social media age. It helps children to manage loss and separation. It promotes placement stability and understanding why they are in care. And it also helps in terms of them children understanding their identity, their family background, and gives permission for them to settle into an adoptive family without having to struggle with feelings of guilt about leaving a previous family. So for adoptive parents, there are great benefits too, and this is something we really try to promote and help them to understand, that they will understand why their children have needed to be adopted, that they'll be able to deal with anxieties about their children's membership with their birth family better. That by promoting openness with their children around adoption, it shows that they can be accepted and valued, and it builds trust, essentially helping the child to be more accepted across both households. We found that it allows adopters to feel more secure in their own parenting of their children, and allows adopters to feel closer to their child, as the child doesn't have an idealised view of birth families. I've worked in adoption for 15 years and have worked with families where children have created a romanticised view of what a birth family may be because of a lack of information, and that's never helpful. For birth families, the benefits are obviously clear, that they gain information and reassurance, and that they're able to deal with their feelings of loss and moving on with their lives, as they undoubtedly have to. And they're able to make a contribution to their child's life after adoption, which is incredibly valued. So as I've said, what's happened already, the messages have shifted in terms of our information sessions, all the way through to the training we run for adopters. The tone has changed. The other thing we've done is to take on board the learning from research and also the learning we have from adopters, essentially that they benefit hugely from lived experience being shared with them. We can send them lots of material and talk at them forever, but actually what is much more impactful is them having a discussion with an adoptive parent who has already been doing some form of direct contact, or listening to the voices of adopted adults or adopted children in terms of what worked for them. Adopters are motivated by messages about how to support their children. So we really need to make sure that they understand that that's why we're doing this, that it's crucial for children's well-being that we're doing this. So I've just included this visual aid that we use in information sessions and training. It's actually from Adoption England, and Adoption England has some brilliant resources, but I just think it captures what we're asking adopters to do. And this is the message to them from the very beginning, really, that they are the custodians of children's connections, that they have to hold those connections for children as they get older. And just the importance of that role and what that role entails in terms of practicalities. So we want them to honour and celebrate birth relationships. So are there photographs, for example, of birth parents on display? Are there special stories that they can tell their children about their birth family? Have they remained committed to sibling contact? Are they continuing to keep the lines of communication open as children get older? And we want adopters to understand that these relationships are so significant, and that speaking warmly and respectfully about birth family and about the significant people in those children's lives has real impacts on children's sense of self. And then just continuing on, you can see it covers some of the points I've made earlier in terms of why it's so helpful, that it builds strong connections, it builds a sense of trust, and it helps with a cohesive sense of identity. And at the bottom, it looks at the challenges. So what do we know makes staying connected not work? What makes it a challenge? And that's if adopters are actively supporting those relationships, and if children are not being allowed to feel accepted and as having a role in both of those families. So there's obviously comprehensive training that goes on with adopters in their prospective adoption assessment period, which lasts for 6 months minimum. There's 4 days. I'm not going to go into all the detail because it's, you know, there's a huge amount, but in terms of some of the topics, we look specifically at identity, children's understanding of adoption, loss, keeping in touch with birth family, early permanence, and we also use guest speakers at all different points of this of the training programme. We also use virtual reality headsets for them to see the child's experience. We also run a training session for friends and family, and I note this because I think it's really significant that we're able to sort of talk to those people who are going to be involved in the wider sense, who haven't had the experience and training and knowledge that adoptive parents are getting, to give them those sort of vital messages around how them speaking warmly about birth family can have such an important positive impact on that child. And just getting them to realise that negativity about the child's past is only going to lead to a negative sense of self. So what we're essentially doing across our journey with adoptive parents, prospective adopters, is the training is very dynamic, lots of exercises, lots of hands-on activity. It's not death by PowerPoint, it's not lots of written material. And the exercises really help prospective adopters to build empathy for birth family, to build their understanding of children's experiences, and it highlights the importance of open communication and engagement with life story work, and also with being supportive of that child's relationship with their birth family. So a little bit about early permanence. It was mentioned by Lisa, and what we found in Cambridgeshire and Peterborough is found nationally, that those early permanence carers have a very clear and accepted role in terms of facilitating family time. So they understand the brief, they understand what their role is. They're well trained and they're willing, and they're able to build connected relationships. And we've seen that it really takes away the stigma from birth families that prospective adopters may feel. It reduces their anxiety, and they're able to develop a greater empathy for birth family. The relationships that we've seen forming at the early permanent stage seem to bode very well for ongoing keeping in touch and more connected life stories. Children are more likely to have a coherent understanding of their birth history because the adoptive parents have a more cohesive understanding of their birth family. And we've certainly seen that in cases that are coming through in our area. As well as the public law outline, there's been some significant initiatives, one of which is the Cultural Change in Adoption programme. started in 23. It's a programme that Beth Neal and others from the University of East Anglia and the Adoption England have been running, and I've been part as a of that smaller working group. There's a cultural champions group, which is for different professionals across the country. All of the videos for the webinars that they run are actually on YouTube, and I've put a link here because they are genuinely accessible and helpful, and they give a lot of lived experience. They have adopters, adoptive people, birth family, and they really are very helpful. We use them with our prospective adopters as well. So I won't go into massive detail because I don't want to go on too long for this one, but we're very connected to the wider adoption world. So we attend a huge amount of groups and different forums. We were also involved in Coram Bath's pilot for the adoption support plan, and I note that because it really does significantly help with adoption support planning, and with allowing all professionals to sort of pause and refocus on exploring birth family relationships. That adoption support plan is actually just coming out formally this month, and there are briefings on the Coram Bath website. And connected to that, excuse me, is the child permits report, which will be out later this year. Again, it has much bigger sections focusing on sibling relationships, on birth family relationships, and it really is helping all professionals, particularly the children's teams writing these reports, to focus on those topics in a more meaningful way. So what's happening? Other things that have been happening is training and resources. We're constantly trying to engage with this topic and support colleagues and educate ourselves and continue to be mindful of what's happening in the adoption world. We ran training with a really interesting group. It's a birth mothers collective group called the Threads of Connection, and myself and a colleague in Adoption Connects organised training, and it was birth mothers' experiences of adoption and letterbox contact, and that was very powerful. We've also been involved in child permanence training across Cambridgeshire, and the reason I note that is because really it was to try to help those who are new to writing child permanence reports to think about the importance of the language used in these documents, given that actually the tone that's set often by the author of that report, the case transfers to another social worker and potentially another social worker, and actually the tone is set in terms of the language choices, and that the significance really of the balance and tone of that document in terms of how adopters will view birth family. So trying really to just get people to think very carefully about how they're writing these. Also to be mindful that plans for children must be sensitive, supportive and tailored to them. You know, as Lisa said, it's not a one size fits all. We can't move from letterbox twice a year default to direct contact 4 times a year default. And importantly, and this is one of my roles, is to QA some of the paperwork for children. It's that children's documents really give a narrative of decisions. They must really clearly set out what assessments have taken place and how maintaining relationship with birth family decisions have been arrived at. What's the rationale for those final outcomes? And we need to see that really clearly in paperwork for children. So again, just to note, the plans must be child-centred, individual, flexible, relational. They must be quality. Adoption panel. We're very clear that adoption is a plan for a child. It may benefit adopters, but that plan ultimately is made because it's in the child's best interest. And we have clear expectations that the maintaining relationships with family members needs to be visible, and it needs to be clearly set out in all the documents. And we do give advice on that subject in panel if improvements are needed, as does the agency decision maker. We also on panel, and adoption panel is where prospective adopters are approved and children are matched with prospective adopters. We have children's voice questions. So we did direct work with the participation teams in both local authorities. And the questions were around a range of subjects, but unsurprisingly, around maintaining family relationships. And these questions are read out as stated by the young people and young adults who wrote them. So you can see here that it's, will you involve the young person in decisions about contact or make choices for them? And do you have an acceptance that birth family situations changes and you can't have a fixed position of no contact? So we always in panel ask questions around maintaining family relationships and plans for wider family. In January, so this month, I had a meeting with the birth relative outreach worker to look at how can we include birth family voices in our questioning on panel. So we're going to begin a piece of work to see how we can achieve that. So the adoption support service, I'm not going to go into all the details, but really to note that we are exploring currently digital offers. So what digital platforms could be of use, and we're reviewing the current postbox service. We're mindful that it was set up some time ago and needs to be reviewed and refreshed. I've put this information on about birth relative outreach worker because I think it's helpful to the court and helpful to those involved in decision making to know that we have a birth relative outreach worker service within the adoption service. So this is a qualified independent counsellor who can do work with families and really help move things on in terms of contact plans. It's open to all birth relatives, not just parents, and can be accessed at any time. And we really realise that actually in the middle of proceedings, families don't like that, they're not going to necessarily want to engage with counselling. But actually what Celia can do is offer a light touch service. So it can be low key, it can be helping parents to be engaged or support them with proceedings, for example. And they're also keen to be involved in facilitating more meetings between birth parents and adopters. And to promote this, we've relaunched material in both Cambridgeshire and Peterborough in January to try to get more uptake of the service and to raise awareness. And that's my bit over. I'm going to stop sharing and Tom Hay will then share his screen.
Thank you, Jade. I'll just try and work out how to share my screen. Hang on, that's not the right button. Right, hopefully, can we see that? I've only got one screen on. If someone could tell me.
We can see it, you just need to click on the slideshow.
Fabulous. Right. So I'll just tell you just a little bit about what Family Finding are doing. I'll tell you a little bit about how we're trying to move this forward to implement some of these ideas into practice. So in terms of Family Finder at the moment, we have a Family Finder representative who sits on the local authority permanency panels. These are where all the discussions are made about children who are likely to have plans of adoption. So that's usually either myself or one of my colleagues who's one of the senior social workers in the Family Finding team. So that gives us an input into thinking about contact ideas, talking to social workers about contact planning, and really trying to promote the idea of contact and direct contact between children and birth families. So that's something that we push within those meetings to make sure that's being considered. Where there's a plan or recommendation for direct contact, we'll prioritise seeking adopters who are open to supporting these arrangements. We're always mindful that it's a good idea. I think, as Jade has alluded to, a lot of our adopters now are being encouraged to support contact during the training, and obviously if we've got recommendations around contact, we'll try and take those forward, and we'll always can come back and review those arrangements as things go along. So the plans around contact are reviewed and considered as part of our linking process as well. So when we identify adopters, we'll think about what the contact arrangements are. We can think about reviewing those contact arrangements at that point, and so it doesn't have to be a fixed plan, because that's the plan that we had from court. But actually, it's about having a flexible idea about what's going to be right for the children, the families, and the adopters. And I'll come on to that a little bit in a minute. So this is how we're going to do it. So safe and meaningful contact. So this is the idea. So it's recognised that there's a need to consider more creative plans around contact for adopted children. greater emphasis needs to be placed on the benefits of ongoing birth-family contact where it's safe and meaningful. We recognise that it's something that shouldn't be considered only at that fixed point in time, but something that needs to be risk assessed and reviewed at different points. And I know that's a lot of what the public law working group has identified. And I think what's really key for us is that it's not just about what happens during your proceedings, what's happening when final orders are made, but actually what are we thinking about next? We know that the point final orders are made is often not when our birth families are in the best place to be thinking about contact going forward with our children. And actually that might come later, when actually becomes a better time to think about whether that's the right plan for them. So how are we going to implement it? So the Safe and Meaningful Contact Guidelines have been developed by Chris Burke, and these provide us a framework to support social workers to consider whether contact is safe and meaningful, to help them with contact planning. So I know a number of local authorities have kind of are using this or seeking to use this model. So we'll work alongside some of them as well to help us to implement it into what we're doing as well. So the guidelines aim to consider not only if contact's safe and meaningful for the child, but also consider the impact of contact on the birth relatives and the carers or the adopters. We can consider these for all different family members within the network and significant people, and it just helps us to provide a more holistic view of the suitability of contact. So by thinking about the access, it's helping our social workers and helping us to kind of organise our thinking around contact. They help us to identify areas of strength and also areas of challenge, which can help us, even if contact isn't right now, think about what steps need to be taken to think about having direct contact in the future. The guidelines, as they set out, consider the suitability of contact based on what they call 5 main purposes. So they'll look at the placement stability, how we manage loss, identity, the impact on the child's identity, the impact of the child's understanding, and into how they integrate past experiences. And in all of these areas, we're trying to think about not only the child and the birth parent, but also the adopter as well. And I think that's one of the bits that's really key in this. And I think one of the bits that's really important to be thinking about when we're in proceedings, that a lot of the time we're in proceedings, might have a birth family relative and a child. We don't necessarily at that point have an adopter. And whilst obviously every effort is made to make sure we find adopters who are willing and capable and able to meet the needs of children who need to continue to have direct contact, we also need to think about the impact of the adopter and the impact on the adopter of the contact taking place, how they can manage and support the child. So this helps us to do that. It helps us to organise that thinking. And then what you'll see is the ideas and principles of this hopefully coming through and being implemented into some of the care plans that are coming through. What's important to remember is we're in very early stages of this at the moment, and from speaking to other local authorities, it does take time. So it is a bit of a slow process, but over the course of time we get there. So far we've had training on safe and meaningful contact guidelines with a number of colleagues within the local authority. At the moment, that's only been Cambridgeshire. Hopefully we may have more training going forward. There's currently a working group being set up, and the working group is going to consider how we implement the guidelines into practice in terms of our processes and procedures, and in terms of how we run that through. We're also speaking to colleagues across other local authorities who started to implement this to get ideas about what they're doing as well. So hopefully there'll be some similarities with neighbouring authorities as well that we'll start to see. The feedback from those that attended the training has been really positive. So I think everyone's really acknowledged that this is a really good idea. The social workers that attended are really keen to use it. So like I say, it's early stages at the moment. And I think hopefully when we get down the line and start to implement this, it'd be good to come back and give a bit more detail and depth to you all about how we're actually implementing it and what the processes are that we're actually using. Because at the moment it is a work in progress. But hopefully we'll start to see some of this coming through. You start to see some of this filtering through within the care plans that are coming into court. So that is our hope. And like I say, always happy to come back and kind of talk more on this down the line where we've got a bit further along. So some reflections from what myself and Jade have kind of been through. So we know this topic's led to some worry regarding the impact on the number of people applying to adopt. So it is really important to take adopters with us on the journey, which is what our training is trying to do, trying to normalise this type of contact. It does feel very big, probably for adopters, but trying to change that culture is really important. We know change in practice is necessary. Some of the important things to really remember. So there's a need for sensitivity and tailored plans for the child. So we can't have a one-size-fits-all approach. So every child's different, and we're hoping by using the guidelines that I've talked about, that will really help us make our plans centered for each individual child, each individual family. Really important to remember that there's currently no additional resources within the REA or the local authority. There's no additional staffing. So we're doing, all of this has to be done within our existing resource. So what I would say to everybody is please bear with us. We are, it's like I say, it might be a slow process, but we're going to get there. We're going to go on that journey with our adopters and with our social workers. In the context of children's service nationally, we know caseloads are very high, recruiting and retention is difficult, turnover is quite high. So again, embedding ideas can be difficult, and we're hoping that the processes that we build can help us to manage that and support our social workers around that. We have to be realistic about the rate of change. So we kind of know where we want to be, but we know it's going to take time, but we're committed to doing it. As an REA, we're committed to doing it, we're committed to driving it forward, and we're committed to working with colleagues across other local authorities and REAs as well to support us to help implement this along the way. I think that is it.
Okay. Well, thank you very much, Tom and Jade, for putting this issue in context for us. That was really helpful. And we're now going to hear from her Honour Judge Gordon-Saker.
Thank you very much, Polly, and thank you very much to everybody else for everything you've told us about this afternoon. For those of you perhaps less familiar with adoption who are attending today for sort of interest, as it were, I really would recommend the Public Law Working Group's report. It's very thorough, it's very evidence-based, as you would expect, and it sets out the current law on adoption, which is obviously a very helpful starting point. I'm sure you plan to read all the cases that Lisa referred you to, but in the unlikely event that you only pick one, then I would recommend the Court of Appeal judgment, which she referred to, Lord Justice Baker, in R&C, because that sets out very much the key cases so far and the background to it, and gives us the present landscape in relation to post-adoption contact. So that would very much give you the context. And if you took the report and that case, that would be a very good introduction to this field for those of you less familiar with it. One of the things in the report is the difficulties with accessing records and information. There's some flow charts at the end which will show you how complicated it is depending on when you were born and the type of adoption. And it's very difficult for people to get information. One of the recommendations is for a streamlined process, which will be very important. In later life, young people often want to find out what happened to them 50, 60 years ago. They want to know if their family and relatives are still alive. And very sadly, parents whose children were adopted often just want to find out if they're still alive and what happened to them. And therefore, if there's a better system for all of those people to use, I think that would be a big help. And if you look at the flow charts at the end of that report, you will see how complicated it is now for everyone. So I do recommend those for you to have a look at. That, of course, leads me on to contact, because if parents and children do have ongoing contact, even letterbox contact, they will understand their background and they may not have so many worries as the parents about what happened to their children, or as the children about where their parents are and what happened to their parents. So better information about that through ongoing contact will make life much better for all of them. Polly's given me the question, which I thought I'd better write down. What are the court's expectations in relation to contact? Well, I'm pleased to say that for me, I think Lisa gave you a slide which actually gave you the answer, and she called that within proceedings. And then Jade and Tom have told us how much work the adoption services are doing with prospective adopters in relation to contact and in relation to understanding the children's background, which means that when you get to court, it'd be much easier for the judge to put in place our expectations. If the prospective adopters understand much more about why contact is important, it will make them more open to it, and they hopefully won't have so many fears about it undermining the family and the placement. They will begin with a presumption in favour of contact rather than fear of it, which will make everything much easier going forward. So what is the court's expectation? Well, I think our expectation will begin much more in the preparation of the evidence for the final hearing in the care and placement proceedings, because we will expect to see analysis by the social worker and by the guardian of the benefits of contact and, of course, of the disadvantages to it, so that the court at the final hearing in the care proceedings can set the template for contact going forward. I think we are less likely to approve a plan that reduces contact and then ends contact when a child is placed with prospective adopters, because, of course, if that plan is approved, contact is unlikely to restart when the adoption application comes before the court. So I think we are likely to expect the better analysis and a template which keeps contact going, so that then when it comes to the hearing of the adoption application, there will be better evidence of the benefits of contact, of how well it's working, and whether it could be kept going in the child's interest moving forward. So that's where our expectations, I think, will be slightly different to now. There will be an expectation that contact is likely to be in a children's interests, and we will want to know, in effect, why it won't be moving forward. And all of that will therefore inform our decision-making at the end of the care proceedings. When it comes to orders, though, I suspect that there won't be very much change, and there were very unlikely to be orders for contact made. What is more likely is recitals. Those of you who appear in front of me will know that I hate lots of recitals in orders, but actually I think here they probably will be needed so that there is a template moving forward. It's expected that contact will take place in this way or that way, this many times a year, and it will be included as a recital for the basis of the way forward. But I think it's still unlikely to result in an order for contact. I think the little paragraph which Lisa identified hidden away in the report about the early permanence placements is interesting, because if those placements have had contact that's working well, if there's a reasonable relationship, albeit at a distance, between the prospective adopters and the birth parents, it would seem very unlikely that contact would come to an end when the evidence tells everybody how well it's been working. And I think that's perhaps hidden away slightly, because in many ways that may be the slightly easier one to deal with when it comes to a final hearing. I would say to all of you that you've been given on the slides by Lisa, and particularly by Jade and Tom, lots of useful materials, lots of links to evidence, which is very interesting. And I think if adopters understand, a lot of it's been done by a team at the University of East Anglia going back over many years in particular. And I think if adopters can see and understand all the benefits of contact, I think it will be much better when it comes to them making the decision, because they will understand why it's in a children's best interest. And for all of us as lawyers dealing with these cases, I think if you look at the various papers and research that they've all referred you to. You will find it very helpful and very interesting. So I would commend it to everybody. I have to say, I'd like to conclude, frankly, by thanking all of our speakers, because they've all put a lot of work into providing all of that information and in taking us through it this evening. So I'd like, on everyone's behalf, to thank all of them for all those valuable presentations, which I think will be available for you all to look at in due course. And I would like to thank Polly, posing as Deborah, for arranging and chairing this webinar for all of us this evening. Thank you very much.
Thank you very much, Your Honour, for that. I think we've lost Tom. I think we knew that was going to be the case. I do think we have time for a question, and I have one question. I think it's going to be directed at Lisa. It arose from Lisa's presentation. So Lisa, if you could help us with this. It says, is the onus on the court or the social workers / local authority to sort out another meeting for contact after an adoption placement order has been made? When it says the court is to facilitate, what is the nature of that facilitation? Do you recognise what that's referring to, Lisa?
I think it's referring to, is it referring to my slide? It was titled For the Court, where I said the court was to consider section 26. And then I said, I'm just looking at my slide, the use of section 51A. It says in some cases that provision may be used to facilitate a review of contact by the court at a suitable time after the making of adoption order. For example, where direct contact is not appropriate at the time of the order, but may be indicated at a time in the foreseeable future. So that if that's what it's referring to, because it says the court is to facilitate, that, as I read the Public Law Working Group, is essentially the ability to list a hearing to review contact at a later date. That's what I think they mean by saying used to facilitate a review of contact by the court. If that's what the question, I think, is aimed at.
But I have to say, if I can chip in, that is quite a change from now, because now the court would make an order for adoption and virtually never see the family again. Whereas that seems to be presupposed that a judge saying it's not right to order contact now, but in X months' time, there will be a hearing. Whereas now, natural parents would obviously have to make an application for leave to apply in the future and jump through more hurdles than they would here if the judge keeps it open.
Yes, that does look like a step change, if we've understood that correctly. I think we've got time for one more question. Well, there's a question about resources and a concern that there's a lack of resourcing if orders are set for direct contact, but they are not backed up by any real support. And the question is there any view as to the need for resourcing to be considered, and also the support that will be available when contact is considered? So is that something, Jade, that you could address?
I think it's difficult to give an answer because I'm not the person with any responsibility for agreeing. If I could agree the resources, I would definitely do so. What I would say is that it's an area where, particularly in the adoption organisation, we absolutely understand that there's going to be increased demand and increased pressure, and so we are reviewing what we have at our disposal now, and being creative. We're able to be creative. What I can't speak to is what the plans are at a higher level in terms of significant changes in resources. But we do already have an adoption support service, and we do already have a post box coordination team. So we're not starting from scratch. It would be around how do we tailor and how are we creative with the resources we currently have. But yes, I would love there to be more resources.
Thank you very much, Jade. Well, I think we're going to draw to a close then. I'd just like to say thanks again to the panellists, and thank you very much everyone who's found the time to join us this evening. I think the slides and a recording will be made available. So I think there've been various questions about whether the slides would be. So yes, they will be in due course. So I hope everyone has a good evening, and I'm going to end the webinar for everybody now.